will take this appeal under advisement. I will now call 124-878 State of Kansas versus Gerald Hambright.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state, and just to confirm 3 minutes of rebuttal, Your Honor. Happily for me, this case does not involve a criminal history question. This does involve what I consider to be a unique scenario as far as what the actual issue is. And starting right off at the top, I will acknowledge that counsel is absolutely right in the cross petition that he filed, or perhaps it was in his response to my petition, that I did not, in the original brief to the Court of Appeals, I did not argue invited error with respect to issue 1. But that's because as the issue was briefed by the defendant in the original brief, he argued it as a straight sufficiency claim. However, it became apparent at the oral argument, and then even more so in the opinion that was filed by the Court of Appeals, that the panel was very clearly lumping together the actual sufficiency claim with the lack of a definition, be it a lack of a statutory definition or a lack of an instructional definition to give the jury guidance on what a dagger is. When you read that majority opinion, you will find very little analysis of the evidence itself, which would be the knife, the dagger, the object in this case. You will find multiple pages of analysis that involves definitions, pictures of daggers from various dictionaries, all sorts of things that have nothing to do with a straight sufficiency claim. And so because in my reading of that opinion, you simply can't look at that and say that this was a straight traditional sufficiency of the evidence reversal. Rather, it's a reversal that was based largely, I would say primarily, on the lack of an instruction telling a jury what a dagger is. And that's where you simply cannot ignore the fact that in this case, the state asked the court to give a definition, to guide the jury and say, this is what we are proposing you define a dagger is.
Let's go back to the issue the defendant argued of sufficiency. Was a definition necessary? Did the state make the choice when it shifted and amended its complaint to specify dagger after having the due process challenge to a broader listing of the terms? Was the approach then from the state going forward for the state that dagger is a common term that doesn't need definition?
It's an interesting question because obviously we did propose the definition. It was the state who suggested that the court give that. So perhaps it would be inconsistent for me to argue that the way that the state proceeded below, that the state felt that it was a term that would be commonly understood by a jury. But I don't know that the fact that the prosecutor asked the court to give a definition necessarily meant that the prosecutor felt that without it, it could not be established. I think perhaps.
I'm sorry, I didn't mean to interrupt.
No, I was just wrapping up by saying, I think perhaps the prosecutor, and I don't want to speak for her, but perhaps she thought that it would just be additional clarity to alleviate any possible concerns. But to your question, as far as whether a dagger, the word dagger is a term that a juror could understand, I think clearly the legislature feels that it is, because otherwise they would have provided some sort of a statutory definition for it. And I think that's always, this case does, or this court does tell us that we presume that ordinary words have ordinary meanings and that jurors can understand them without being given specific additional legal definitions.
And I noticed that you chose not to have opinion evidence, or expert testimony about this is how we would classify this.
Right, yes, it was the only witness in this entire case was the officer.
I assume the state's position is that that's not necessary, that from the circumstances of the appearance of the object, the jury could conclude it was a dagger, as I assume what the state's theory of the case would be.
I believe so, and I think that is logical, that a jury, a common juror, a reasonable person could look at the item, which they had the object itself, plus all of the pictures that helped give them additional guidance as far as the dimensions of both the blade and the handle. And I think a common juror would be able to look at that and have an understanding and differentiate, okay, is this a dagger, or is it, I know in the majority's opinion, they point to things like a kitchen knife or a letter opener or various other objects. And my position is that yes, a common person is going to be able to look at an item. And I think, again, when you look at the object in this particular case, and I know the pictures are in the record, and counsel and I both have copies of them as well. I think very clearly a person could look at that and see how that is distinguishable from something like a butter knife or a letter opener, or even, some sorts of common pocket knives. Pardon me?
A chef's knife? I mean, we're not trying to prevent these defendants from being able to cook vegetables, are we?
Right, and I think that, again, as I look at this item, and I will acknowledge that I'm not the most handy person in the kitchen, so I sometimes have a hard time visualizing this particular types of knives that are used in cooking. But as I look at this particular blade, my belief is that a reasonable juror looking at this and having the evidence in front of it would be able to distinguish and realize that that is an object that, quite frankly, I have a hard time thinking that anybody would possess that type of an item to do anything other than stab, inflict some sort of injury on. And I know the argument could be made, well, perhaps this is similar to a hunting knife. Well, again, hunting knives are intended to inflict damage. What do you use a hunting knife for? You use it to either wound an animal, or after the animal has already been killed, presumably, to then gut the animal. This is not something that would be used similar to for cooking. I don't think anybody could look at this and say, yeah, this is something where there's any reasonable argument to be made that this person is using it to spread butter on a roll, or cut a piece of meat, or anything else.
Well,
But
this person, there's some indication this person may have been homeless.
correct.
So if you can only have one knife to do everything, this knife be it? Cook vegetables, to, trim twigs for a fire, to, I mean, there's another side to this knife too that has of some purpose. I'm not sure what.
But I think as we get into that analysis, then we're deviating from what we should be looking at if it's truly a strict sufficiency of the evidence argument. And I think that's one of the things that Judge Klein pointed out in her dissent, is that the majority seems to be trying to almost compare this evidence to what could be considered an ideal case, where you've got the perfect evidence, where you have an expert who's come in and said, this is exactly what a dagger means, and here's my qualifications on how to tell you that. But that's not, in a sufficiency context on appeal, that's not what we're supposed to be focused on, is coming up with potential hypotheticals or saying, could a jury have interpreted differently? If the jury had looked at this and decided that it was not a dagger, they would have acquitted him. And as the state, we would have had to have lived with that verdict. That's a decision that's up to them to make. But they saw the knife, they saw the pictures of the knife, and they determined that this was in fact a dagger. And again, I think when you look at this particular object, you see a very sharp pointed blade. I would note, much like Judge Klein did, I think that the majority, first of all, I think they were incorrect in using the definition and then saying, well, generally speaking, these definitions seem to refer to blades or edges plural. I think fewer than half of the definitions that the majority itself used actually referred to blades or edges plural. But as I look at this picture,
So is the test then whether it can be used for stabbing? Is that the only test for this sufficiency?
I think that to the extent that there needs to be a definition, a specific definition, I agree with that definition that Justice Biles proposed in the dissent in Harris and that Judge Klein would have used in this case as well, which is, yeah, a short pointed blade used for stabbing. And that is consistent with the dictionary definition, I believe it was from Webster's. And again, I know that the majority went back and came up with 12 dictionary definitions, some of which dated back, I think, as far as the 60s.
Counsel,
Straight razor fit that. I mean, that, because the statute says the definition of a knife includes a straight razor.
Yeah, there's the dagger, dirk, stiletto, straight razor.
I understood you to be saying that the definition you're providing is the definition of a dagger. As
Yeah,
opposed to,
yes.
so I guess my question is, why do we need definition? I mean, it's like the old saying that it becomes turtles all the way down. Like, why not provide a definition of stab?
No,
Why
right.
not provide a definition of sharp or point?
Exactly.
Like why isn't this just an ordinary English word that we entrust to jurors in their common understanding?
No, I appreciate that question and I want to clarify. I think I agree with that position. My point is that either way we win. This is either something which I believe primarily that this is a common word that a common juror would understand that does not need a specific legal definition. Secondarily, I would argue that if this court does think that a definition is needed, it should be the definition that Justice Biles used in Harris from the dictionary and that Judge Klein used in this case. And that even under that definition, if it's necessary, the state would still prevail in this particular case when you look at the evidence. But what I take issue with the majority opinion primarily is where they are so focused on the lack of a definition and saying that then creates a lack of sufficient evidence, when in this case, to the extent that a definition is needed, it was the defendant who adamantly objected to that being given to the jury. And so on appeal, even though he wasn't the one who initially framed it as an instructional issue, he shouldn't be able to prevail based on the lack of instructional guidance to the jury. I'd also note another issue that I take with the majority's opinion is that I don't understand why they even addressed the residual clause in this case. The residual clause was a non-factor. It was not instructed upon. The jury had no way of knowing it ever existed unless they are reading Kansas statutes as a hobby. They have absolutely no idea that there's a residual clause in the statute. So that is kind of a non-starter as far as why that would even be discussed. So again, yes, to clarify, our primary position is that this, like thousands of other words that are included in elements of crimes or in jury instructions, it's a common word with a common meaning that a reasonable person can understand, and that under that test, we met the sufficiency of the evidence. But secondarily, if this court were to decide, like the majority, that a definition is needed, it should be the definition from Harris, from the dissent, and that under that definition, the state also provided sufficient evidence that this object met that definition and therefore supported the conviction.
I ask, you're suggesting that the instructional error was invited, right?
Correct.
What, if that is true, what impact would that have on the prosecutorial error argument, which sort of picks up where that instructional error leaves off, where the prosecutor then is arguing based on the instruction, an expanded definition of what constitutes a knife beyond the charging document?
Yeah, and that's why I think like so many, or like all prosecutorial error claims, you have to look at the totality of the closing argument. And when you do that, you'll see that while the prosecutor did mention that definition, that included things like the dirk and stiletto and straight edge, she very quickly followed it up and made very clear throughout closing argument that the question in this particular case is whether this is a dagger, and even told the jury, is it a dagger? That's for you to decide.
I guess my question was more like, if it is invited error, then does that sort of give the prosecutor a free pass then for making that type of argument for an instruction that was invited?
Yeah, to
into
the extent that,
proceedings?
yeah, to the extent that this is the definition or that this is the instruction that the defense wanted to then argue that the prosecutor stepped outside the bounds of fair argument and then, you know, essentially parroting that language to the jury. Absolutely. I think that too is kind of an inconsistent position taken by the defense. But yeah, more broadly, my position is that when you look at that argument as a whole, she made very clear that in this case, what we were alleging is that this is a dagger of those 5 things enumerated, that we're arguing that this is a dagger and that ultimately it was up to the jury to decide. And the defense attorney also very clearly recognized in this case that that was the particular object or term at issue. So there's no chance that any juror was confused as to what they were being asked to determine in this case. I'm past my time. I will reserve the remaining comments for rebuttal, if any. Thank you.
May it please the court, Gerald Hambright appears through counsel Casper Shire, Kansas Appellate Defender. Gerald defended this case on a theory that State v. Harris does not allow a business as usual approach to prosecutions for criminal possession of a knife. The state had to amend its charging document to avoid getting its case dismissed, and that can't be a purely cosmetic change. It has to come along with some requirement that the state present evidence that the blade Gerald possessed was in fact a dagger and not just some other object that all of us would call in everyday speech a knife. They didn't do that. Nobody at trial said the word dagger until after the close of evidence. The first time it came up was in the defense motion for judgment of acquittal.
Well, I mean, in closing, the prosecutor said, is this a dagger? That's for you to decide.
And that is argument, Your Honor. It's not evidence.
But the pictures were admitted into evidence, and was the object itself admitted?
It was. It was.
So that's evidence.
That is evidence. But the state had a burden not just to, let me analogize this to a drug prosecution, Your Honor. We've got a white powder. I can put a witness on the stand. He can describe that white powder. He can tell the jury what it is. He can show the jury can put their hands in it if they want to. But they still have to have some evidence that that white powder is cocaine.
Does your argument depend on that analogy? In other words, it strikes me that you're saying that whether an object is a dagger or not is outside the scope of the common knowledge and understanding of it. In the same way that whether powder is cocaine is outside the scope.
Yes, I am saying that.
If that's not true, then you can't prevail.
Well, the problem is nobody gave this jury evidence that this is a dagger. It didn't happen.
So you're saying there has to be direct evidence?
No, there doesn't.
Circumstantial evidence doesn't work? Or-
No, I'm not saying that, Your Honor. And again, I think that.
And this isn't even circumstantial evidence. It is direct evidence. It strikes me what you're saying is that what's required is opinion testimony, whether lay or expert. I mean, somebody has to get on the stand and say, this is a dagger.
No, I don't think that's true, Your Honor. I think, for example, one way you could put on evidence that this is a dagger is any company selling knives has a website now. They're marketing their knives. If a particular blade is marketed as a dagger, that's fairly good evidence that it's a dagger, whether or not you have an expert testify or not. So there are ways the state could have put on this evidence. They didn't do it.
Would it be the same thing if it was a switchblade? Would you have to, if there was a switchblade introduced into evidence, would you have to go on a website and do the same thing, or a straight-edged razor?
Yes, I think you would have to present some evidence that this, post-Harris, it can't just be that it feels like the right kind of knife. That can't be the analysis that we're doing anymore. There has to be evidence that this particular blade falls into this specific subcategory of knives that the legislature has designated as criminal.
I just struggle to understand why, when you put the object in front of the jury, that's not evidence. That's the disconnect that I sort of am struggling with your argument.
It's evidence of the dimensions of the blade. We know how long it is. We know it's sharp on one side. We know it has a serrated
Why isn't it just
spine.
evidence for what it is?
The same reason that,
Again, it depends on your cocaine analogy, which I understand.
well,
That you're saying that whether an object is a dagger falls outside the scope of the ordinary understanding and knowledge of a juror.
I guess I'm going to do what my opposing counsel did and say, yes, I agree with that this is outside the scope. I am making that argument. But separate and apart from that, I think there has to be some evidence, even if it's, if the officer had said, look, I've seen a lot of knives in my day and this is a dagger, that is at least some evidence. What's that's based on? I don't know. And I think, maybe we get into, whether he's qualified to testify as an expert on that subject at that point. That never came up because that evidence never even got put to the jury. So we.
But once,
Sorry, just 1 second, just as well. If the statute said it's unlawful for a convicted felon to possess a cat, and the state came forward and said, we caught this guy with a cat, and here's some pictures, and here's the cat.
Right.
And a juror make a determination without any other evidence whether or not this defendant, in my absurd hypothetical, possessed a cat.
And I guess this goes back to the first point that we were talking about, is that I don't think daggers are like cats. I think daggers are more like cocaine than they
cocaine.
are like cats.
So it's that spectrum that we're discussing.
We are, yeah, obviously we're arguing about where this falls on that spectrum, and I think
That's helpful. Thank you. Right.
and so, no, I think my question probably is answered by your response, but then essentially once you have a definition, then that evidence would have been sufficient. Really, I'm trying to nail it down. It really is the absence of a definition that's the problem here, because had a dagger been defined and the jury is shown the actual object in question, it seems like that would have been enough. So really, it's the absence of the definition that is the basis of the argument, right?
no, I don't, I see the sufficiency argument and the instructional argument as two different arguments. And I would love to be here making the
So you
instructional-
would have said, even in the absence of a definition, as long as somebody would have said, this object you see is a dagger, that's what would have pushed it across the line.
I think unobjected to, that would have been enough to push it across the line. Yes. If I'm defense counsel in that situation, I'm objecting. I'm at least trying to get whoever is saying this, testing their qualifications as an expert. Because I think if the Court of Appeals opinion teaches us one thing, it's that figuring out what exactly a dagger is not the easiest task in the world.
An expert to define that this is indeed a dagger, but not to define what a dagger is, right? Because that would be the legal question.
That would be a legal question, but yes, an expert certainly could testify, hey, these are the characteristics of this particular blade that make it dagger-like, right? And that's what's missing at trial.
So in other words, your hypothetical about having a website show that this is a dagger, you would have objected to that too, because that's not,
I may have objected to it. I don't, whether or not that objection is valid is of course up to the district court to decide. I'm not sure I could win that objection because that would be not direct evidence that it's a dagger, but at least circumstantial evidence that it is. I mean, it's,
so going forward in every case under this statute, we're gonna have to have an expert.
I don't think that's a bright line rule. But I think drug cases are a good analogy. Does the state plan on having a KBI chemist at every drug case that they're going to prosecute? I believe they do. And I think that would certainly be best practice moving forward, Your Honor.
There's no such thing as I know it when I see it in this world of a knife.
I don't think there is, Your Honor, and I think Harris forecloses that. Because the whole point of Harris was to prevent this standardless sweep, not yes from police officers, yes from prosecutors, but also from juries, is deciding, you know, this particular knife feels like the kind of knife that ought to be
I
criminal
just
to me.
don't see the application of Harris, I guess, because it dealt with the residual clause.
It did deal with the residual clause, Your Honor. But looking at the big picture,
I mean, you haven't raised a vagueness challenge to the word dagger,
no, we have not.
and Harris was a vagueness challenge.
Yes,
And so I guess I'm just not connecting the dots in the same way. I would like to hear how you connect the dots, I guess is the way to ask the question.
sure. I want to emphasize a couple of things. First of all, you know, this case didn't get charged for about a year after Gerald accepted a ride into town and turned over his blade, his knife, whatever you want to call it. He sits in jail for about 600 days, or some of it is learned, but he's in custody for about 600 days. Much of it after Harris comes down. All of that time, he's charged under the residual clause. Then 4 days before trial, the state amends its complaint and says, okay, not the residual clause, dagger. And then essentially trots out the same prosecution that it would have rolled out to prosecute under the residual clause, with no evidence that this is, in fact, the type of knife that checks the boxes to be a dagger. So, big picture, I think Harris is important because this whole prosecution is the state trying to get around Harris. And they shouldn't be allowed to do that just by changing one word in the charging document. There has to be some change to their substance of their case, and there wasn't.
What do you think the significance is that knife in the statute isn't defined by anything that I would like classically refer to as a knife? I mean, it doesn't refer to a paring knife or a chef's knife or those, you know, something that would be readily understood to be a particular type of knife.
Right. And I think part of the problem there, Your Honor, is that the legislature has never come back to look at the statute again after the residual clause was struck down in Harris, because it did have a much broader sweep pre-Harris, certainly.
That have significance here?
I think it does. Because if the legislature wants to, daggers, dirts, switchblades, stilettos, straight edge razors, these are very, very specific technical kinds of knives. And if the legislature wants to amend the statute to allow, prosecutions for more general, long knives or double-sided knives or, more general categories of knives, they certainly could, and they haven't, at least to this point. And I think unless and until they do, the state needs to present evidence that the blade they're prosecuting falls into one of the strictly defined boxes that the legislature has laid out.
It just strikes me that the error that I'm hearing from your argument is that what it takes to check those boxes to be a stiletto, dirt, dagger aren't within the realm of common understanding. And they have to be spelled out, which means that's a legal question, whether they should have been defined. But if that is true, is that the argument you're making in this appeal? I mean, has that issue, it's really not the sufficiency, it's really more about an instructional problem, isn't it?
I still think it's both, Your Honor. I think I'll be clear, I think an instruction would have gone a long way. In fact, I think Gerald's jury would have acquitted him if they had been instructed that a dagger is a knife that's used for stabbing, because there's absolutely no evidence that this knife was or that it's designed for that. But I still go back to the evidence. The evidence wasn't there. Even if they had been instructed, even if they'd been given, the definitions that the state asked for, I would still be arguing sufficiency because there was no evidence to support the definition that the state asked for, that this knife could be classified under the definition that the state asked for.
But without that definition, how is that testimony carry any weight with a jury? I mean, somebody says it's a dagger, but we don't know what a dagger is. You know what I mean?
I understand. But again, I come back to, I think the jury should have been instructed. I do not think defense counsel should have been objecting to that instruction. Maybe they should have been offering one of their own. Maybe we should have been arguing about competing instructions. But the district court should have instructed on some definition of dagger here. I think it was a mistake not to. And whatever definition of dagger you settle on and give to the jury, it's argument that there's still no evidence that would conform, that would show that this particular blade fits into the box.
I just point of clarification. You said part of the state's burden would have been to show that it's used for stabbing. And I might have misheard you, but this is a possession crime. It's not, if we just take it out of the category of a knife, if it's a firearm, there might be a possession of a firearm, but no showing that he intended to shoot somebody or even fire the weapon. So is that really a part of what we're looking at? How he was going to? I don't think it is, but just help me
No,
with that.
I don't, Your Honor, and I see I'm out of time. But if I could at least get through this one, Your Honor. I don't think how Gerald intended to use it had any bearing on whether or not it was a dagger or not. But I think the way it's designed, nobody uses a double-edged stiletto without a blade guard to chop vegetables, right? The only reason we have knives like that are for self-defense or debatably self-offense, right? Gerald's knife was not that kind of knife. As I think Justice Wilson pointed out earlier, this is a knife that could be used for any number of things beyond stabbing. which, maybe,
Sorry to interrupt, but real quick, it sounds that at least in part, your argument is this isn't a dagger.
yes.
That, in fact, whatever the evidence was, no reasonable juror, even using their common understanding, could have come to the conclusion that this was a dagger.
Right, this is a utility knife.
The way I framed it is slightly different from the sufficiency claim. I mean, it's sort of it is sufficiency, but you were sort of camping out on no evidence side of things, whereas it seems to me now you're transitioning to, well, whatever the evidence was, this isn't it. This jury reached a conclusion that just simply cannot be supportable because this is not a dagger.
I appreciate that I'm mixing those two somewhat distinct concepts, but I think it's difficult to unravel them
Yeah.
sometimes. I think some mixing is inevitable.
Questions? Anything else you'd like to add in closing?
We would simply ask this court to affirm the Court of Appeals and to vacate Gerald's conviction.
May it please the court. Just to pick up a few key points here, and I think I'll probably be the first person in history to make this particular statement. Yes, I would argue that daggers are more like cats than cocaine. I think that there is a much greater common understanding among a common person about dagger than there would be about the ingredients of cocaine or any particular drug.
Counsel, if that's true, why was this not charged originally as possession of a dagger?
Well, I think it was charged originally, it was before Harris, so this was charged when the residual clause
Right, but
was
if it's
still
so
valid.
obvious that it's like a cat, there's some resonance that the defense counsel's argument has some resonance that, look, for 2 years, however many days, 600 days, whatever, charge was under the residual clause. And now you switch it because of Harris.
Well, it
But if
wasn't
you really thought it was a dagger from the get-go, why didn't you charge it that way?
It wasn't just charged under the residual. I think it was originally charged under all of I think it included Dirk Dagger, and then the record will speak
Okay.
for itself. But I think just in general, I know as the appellate division, we always tell our charging attorneys and our prosecutors to, err on the side of starting broad and then narrow. If you start narrow and go the other direction, then you're creating all kinds of problems. And so we generally tell them, look, you don't have to narrow it down in the complaint. You can keep it. We always try and tell them, keep the to wit language out of the original charging document, because you never know how the evidence is actually going to play out. And so I think that's generally the answer to that question in a broader perspective. But
But then maybe beyond that, why ask for a definition if it's more like cats?
right. And again, I don't think she had to do that. I think she was probably just trying to cover all the bases, and, maybe having read Harris and having been aware of that case, was just thinking to herself that out of an abundance of caution, let's give the jury some guidance on that. But I do think that was an unnecessary step that she took. Because again, I do feel like this is more like the cat analogy. And to the Chief Justice's point, I think it is one of these situations where you know it when you see it. And I think that sometimes when you try to define an object like that, then it creates additional problems. And to Justice Stiegel's question to me originally, then, okay, let's say you define it as an object that is pointed and used for stabbing. Then do you then have to decide or define what is pointed? Is there a certain parameter that has to fit within then? And what does stabbing mean? So I think at some point you just have to trust jurors to understand and be able to make that determination. I would say that as the cocaine analogy was being discussed, one thought that I had is, if there is a case where somebody is charged with possessing cocaine and the state does not put on an expert to testify about lab results showing that it was in fact cocaine. You just put the bag of cocaine into evidence, you let the jurors see it. If we don't put on that lab result, we're probably not going to get past a jury as far as getting a conviction. But if we do, if the jury looks at that and they determine that that's sufficient evidence, whether you can determine that circumstantial evidence or direct, however you want to refer to it, it's evidence of a white substance, and let's say it's in a baggie packaged the way that cocaine usually is. If the jury looks at that and they determine that it is cocaine and they convict on appeal, I don't think we lose that case. I think that there's judged against a sufficiency of the evidence standard, light most favorable to the state, look only for evidence that supports the verdict, don't search for contrary results or other interpretations of the evidence. I think that even in that case, there's a strong argument to be made that that would withstand a sufficiency. Now, again, I'm not saying that we would be likely to get the jury to convict, and clearly a good defense attorney would point out the lack of test results to the jury. But if the jury convicts in that case, I think that even using the cocaine analogy, when you have the evidence itself, and Justice Stegall made a point that I made in the brief, and I certainly stressed this at the oral argument, the defense is focusing on the lack of an officer or somebody coming in and using the word dagger and acting like that would be the gold standard. I would argue that the actual object itself, shown to the jury, they can pass it around the jury room, they can inspect it, they can touch it, they can hold it, they can do whatever they want with it. I would argue that that and the pictures is the strongest evidence you can get. It's the actual object, and then they can look at it and they can determine. And one final point, just to pick up with a question that Justice Wilson asked, noting that the statute does not refer to things that would be common, kitchen knives or cooking knives or things of that nature. I think that's telling in that it shows that this is limited to objects that are clearly designed for purposes that are not common kitchen uses or pocket knife uses. You're talking about all of these objects are things that the general usage is to inflict damage on another living being.
Well, are those things mutually exclusive then? If I find this is a utility knife. It's not a dagger. It's not I had to look up Dirk, frankly.
We're in the same boat there.
So are they mutually exclusive?
I could certainly see some items where there would be overlap. I'm far from an expert. I'm not a hunter, so I don't really know the ins and outs. I'm sure there are multi-purpose knives that could, one person might use it primarily or exclusively for a utility purpose, while another person uses it for violence against another person. So I don't know that I want to commit one way or the other to saying that they're mutually exclusive. But again, we're looking at the knife in this particular case. And as I view that knife, I think perhaps just a common sense way to look at it, which again, keeping with a common understanding of the word, if I see somebody holding a butter knife, my instinct is not to be fearful for my own safety. I'm not worried that that's an object that is used for stabbing. If I see somebody holding that knife near me, I'm certainly going to have a lot of reservations because that is certainly a sharp pointed knife or blade that in its common use could be used for stabbing. So I know I've made a lot of alternative arguments there, but I think that just highlights that regardless of whether you feel a definition is or is not necessary, under any of those scenarios, our position is that the state should prevail in this case. Thank you for allowing me to go past my time. And if there are no further questions, we would respectfully ask that this court reverse the Court of Appeals and reinstate the defendant's conviction.
I see no questions. Thank you.
Thank you.
Thank you to both counsel for your arguments. The court will take this appeal under advisement.